welcome. Thank you for joining us, and please invite your family members, friends, colleagues at work, and join us every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. And of course, that is currently 6 p.m. Nigerian time. I think it's 5 p.m. or so in the UK. Wherever you are welcome to our live podcast. We'll continue today. What part are we today? 13. Okay, this is going to be part 13 of immigration update under the current administration. So, as we proceed, if you have questions, send in your question. This program is for 1 hour. We'll try our best to answer as many questions as possible. But normally, before we go into today's questions, we like to address a few things. There are some specific questions that we were not able to reach last week, and we hope to get there this week. And also, before we go into question and answer session, we also like to talk about updates. Updates, that is, those things that have happened between last week and today, since we are talking about updates on a weekly basis. This Donald Trump second coming is an administration that is full of it's not short of events on weekly basis, on even on daily basis. So every week we have new information. So between last Wednesday after our podcast and now, a lot has happened, and I'm going to summarize some of them, some of the things that happened. First and foremost, when the instruction or the memo was put out that those who are in the United States unlawfully must register, alien registration, some organizations challenged it in court, and they requested a temporary injunction against the registration. So on Friday, the court denied that request for a temporary injunction. So the alien registration has actually gone into effect from Friday. When it's 11? I think 11 was Friday. April 11, yes. So it went into effect on Friday because the judge, the district court judge, denied the motion for stay. But the actual case itself is still pending. It is the injunction that was denied. So that means that if you are here and you have not registered before, you need to register. Otherwise, they can use that as a basis to arrest you. But if you are here in the United States, if you enter with a visa, it doesn't matter what kind of visa, whether it is a visiting visa, a student visa, any kind of visa, it means you already register. If you have ever applied for asylum, it means you already register. If you have ever filed anything that requires you to take fingerprinting to provide your biometrics, it means you have already registered. So it is only those who entered without a visa and they have not applied for anything. Those are the kind of people that are yet to register. So majority of my listeners right now, you may have registered. So you don't really need to bother yourself if you have registered. It is only for those who have not registered. The second thing that I like to say today, still in the same direction about court cases. This is the humanitarian parole that was terminated for the citizens of CHNV, that is Cuba, Haiti, Nicaragua, and Venezuela. Yeah. So the court actually granted injunction in that case. So in that particular case, the court granted an injunction against the Donald Trump administration. So under the injunction, at least for now, the parole cannot be cancelled. So that is what the court says, pending the outcome of the case. The main case is still pending, but there's a temporary injunction. So that means that particular termination of the parole will not go into effect because injunction has been granted in that particular case. The next thing, which is really, really troubling because a lot of people may end up being deported because of this. The EOIR, that is Executive Office of Immigration Review, they just published a memo authorizing immigration judges to pre-terminate any asylum application that they consider incomplete. So what that means is that if you submitted an asylum application and you did not answer all of the questions in the application, or you left something undone in the application, maybe you are supposed to attach a story, you didn't attach it. Maybe you are supposed to answer a particular question in the application, you didn't answer it. So what this memo is saying that immigration judges can actually look at the application and pre-termit it. Pre-termit simply means that they deny it even before you have the opportunity to go for a hearing. And of course, once they do that, that will render the respondent, the alien, the foreigner, that will render the person without a relief, and then the immigration judge will go ahead and issue a removal order. Even applications that were filed by lawyers may still suffer the same fate. This is why it is very, very important. If you have a pending asylum application and if you have a case in court, please contact your lawyer immediately. Let them review the application and make sure that all the necessary supporting documents have been filed with the court, and be sure that every question that ought to be answered have been answered, because the Immigration Executive Office of Immigration Review, that is the body that employs immigration attorneys, immigration judges. So they are saying that judges should go ahead and deny every application that is not complete. You know why they are doing this? The Trump administration is trying to deport as many people as possible, while at the same time trying to reduce the number of immigration judges, while at the same time they want to clear the backlog in the court, but they don't want to waste time. They want to find a way to just deport people without going through the legal process. So please don't play into their hands. Don't play into their hands. If you have a pending asylum application in court and you are listening to me right now, please talk to your lawyer immediately. Your lawyer may not even be aware of what I'm telling you now, because this is an information that was released to us this week. So this executive order, this policy was signed on Friday, April 11th. It was signed on Friday, so your lawyer may not even be aware yet. So don't let your case be the example. Don't let your case be the test case. Don't be the one that they will use your head to break the coconut. So if you have a pending asylum application, especially if you are in removal proceedings, please contact your lawyer. Make sure that all applications are properly completed. Make sure that all the necessary supporting documents are attached and filed in court. If your application requires filing any kind of brief, make sure that all these are done. For example, if you are applying for asylum on the basis of a membership in a particular social group, especially those who are applying based on female genital mutilation, you are applying based on sexual orientation, make sure you submit the brief indicating that you qualify as a member of the particular social group. If you have a lawyer, quickly do this before any immigration judge will pretermit your case and order you removed without going through the immigration trial. This is one of the policies of this new administration. Please don't be a victim. Very important. The next thing that I want to say, which is still closely related to what this new administration is doing, is that they have also signed a public, what do we call this thing? There's a term that I'm trying to remember right now. Let me see if I can remember it. When something is published in the Federal Register.
Public record?
No. A Federal Register for public to comment.
Oh.
Anyway, I will say it in a way that people will understand what I'm trying to say. I can't remember the specific language that we use now, but what it simply means is that when any administration want to enforce a policy, and this policy is one that they want the public to comment, they will publish in the Federal Register and give people 30 days to comment. So in this particular case, they have published the notice, and this is the comment period. They want to reduce the number of members of the Board of Immigration Appeal from 28. They want to reduce them to 15. For those who may not understand what the Board of Immigration Appeal means, that is the body that handles appeals from immigration courts all over the United States. That is the same body that handles appeal when a U.S. citizen files I-130 petition on behalf of a spouse or on behalf of anyone. If that petition is denied and you file an appeal, the appeal goes to the BIA, Board of Immigration Appeal. Now, there is one BIA representing the entire United States. There is one Board of Immigration Appeals representing the entire United States. So that BIA, that board representing the entire United States that handles appeals from the denial of I-130 and appeals from denial of all immigration courts in the United States. Currently, they have 28 members. The Trump administration is proposed rulemaking. That's what I was trying to remember. The Trump administration is proposing to have a rule that will reduce the membership from 28 to 15. You remember, I think about 2 or 3 weeks ago, when I was talking about some of the policies of this new administration, I remember pointing out that one of the specific policies was the one instructing the BIA to expedite appeals. They don't want cases to linger for years. They want cases to be handled with expedited processing and everybody deported as quickly as possible. So now, rather than allow these members to handle the appeal, they now want to reduce the number of the judges from 28. They want to reduce them to 15. I'm not a mathematician, but I think that's about 48% from 28 to 15. Because if it was from 30, that would have been 50%. From 28 to 15, that's about 48%. You will see that this is ridiculous. We are really in for a serious trouble in this country when it comes to immigration. The unfortunate part of it is that majority of American citizens don't see anything wrong with what Trump administration is doing. This is because many of these people, they look at immigration from the angle of those who enter the U.S. without inspection, those who cross the border, those who jump the fence, those who swam into the country from the neighboring countries. That is the angle people are looking at it, but they are not looking at what about those who enter legitimately, those who entered with a visa, those who file applications legitimately, those who are legitimately married to a U.S. citizen and the U.S. citizen spouse are filing petition for them, and immigration is denying it. You see, because I've practiced immigration law for so long, I've seen so many things. I've represented a client who was legitimately married to his U.S. citizen spouse, and they have been married for more than 28 years. Legitimate marriage. They have children, and they attended interview. Of course, without a lawyer. The petition was denied. You can imagine a marriage of 28 years that have children, and immigration still denying it. So what the Trump administration is trying to do now is preventing people like that from having a proper appeal process by instructing the BIA to expedite all cases, by reducing the number of immigration judges, appeal court, the board judges. The members of the board, they are all lawyers, they are judges. They are usually immigration judges who are promoted to the BIA. Now they are proposing to reduce their number from 28 to 15, bearing in mind that only one BIA represents appeal from the entire United States. This is really going to be problematic. And this is one of the reasons why they are telling the immigration judges to pretermit asylum cases, so that many of these cases will not even have the opportunity to go on appeal. So once they look at your application and they determine that the application is not properly completed, the judge will just deny it, order you removed. So you may not even have the opportunity to go on appeal. Because what that means is that maybe the last time you went to court, they told you that your case is coming up October 10, 2025. Now we are in April. The immigration judge look at your asylum case and concluded that this application is not complete. Pretermit means that the immigration judge is just going to issue a decision, even while you are still expecting that you are going to court in October. You just receive a decision that you have been ordered removed. I mean, you can imagine. Because I've experienced pretermitted cases in the past, that's why I know how these things work. When cases are pretermitted, they don't allow you to come to court. They don't wait until the hearing date. They just go ahead and issue a removal order. I've seen it before. This is what Donald Trump is trying to bring back again. We have to collectively stand up and fight all these things. I hope those who are lawyers, I hope those who are American citizens, I hope those who have the opportunity to comment on this rulemaking will sign up and oppose it, because this is going to lead to great injustice. It's going to lead to a lot of people being deported without trial. It's going to lead to a lot of people being prematurely found ineligible. We already know that Donald Trump administration it does not give a damn about procedure. I mean, we can all see how it is playing on television. The foreigner that was wrongly deported, even when the administration admitted that this was an error, and the court ordered, even the U.S. Supreme Court ordered that they should bring this person back. They should facilitate that this person return to the U.S. We have seen how they are handling it, and they are turning it into a political spectacle. So the administration is already known. They have already, within this short period, they have already created a niche for showing that they have no respect for the rule of law. Americans, we need to stand up. We need to stand up and defend the rule of law. The rule of law is the most single thing that makes this country stand alone. That is what makes this country great. That is why people like us, can come from Africa and come here knowing that we were all affected by the same laws. But now they are trying to change all these things. We need to stand up. Don't say it doesn't concern you, because it may not concern you now, but tomorrow it may be your turn. When somebody is facing injustice now and we are not speaking out, it will soon be your turn, and you may not have anybody speaking out for you. That is why those of us who are American citizens, we need to stand up and fight this. Please remind me, we need to provide the link where people can comment on this rulemaking to oppose this reduction of the BIA members from 28 to 15. Yeah.
Finish what we're going to stop.
Just remind me after the podcast, we'll put maybe a link where people can go and comment to let them know that we are opposed to this decision. It doesn't become final yet. It's going to become final by May 11. May 11, because the notice is for 30 days and it was effective April 11. Now, is there any other thing I'm yet to mention before I go into questions and answers? I've spoken about the motion for stay that was denied, alien registration. I've spoken about pre-terminated, incompleted asylum application. I've spoken about temporary injunction that was granted blocking the humanitarian parole for citizens of Cuba, Haiti, Nicaragua, and Venezuela. I've spoken about, one more thing I'm here to talk about. Again, another district court judge in Seattle, Washington State, ordered the Trump administration to ensure that those who have been granted asylum before Donald Trump was sworn in, they must be processed. The administration has been told that they cannot cancel asylum for those people, the refugees who have already been vetted. Those who are outside the United States, they have already gone through the process and they have been approved. Those who are in the United States, they have already gone through the process and they have been approved. That the administration cannot stop it. Remember, one of the executive order of Donald Trump when he was sworn in was that they were going to suspend asylum processing for refugees coming into the United States. So a district court in Seattle has granted an injunction that no, they cannot do that. At least if your own administration does not want to process refugee status for people, those that have been processed and approved before you were sworn in on January 20, you cannot stop those people from entering the U.S. as asylees or as refugees. So that court has granted that injunction. So I see that we already have a lot of questions. I just want to make sure there is nothing major that I need to say that I've not mentioned, because there are so many things, but we have very limited time. So let's see. I've also talked about... there have been... Let me quickly mention this before I go into the question and answer. There have been rumors. I call it rumors because anything that is not official, as far as I'm concerned, I call it rumor. But there have been reports in the news that USCIS have stopped processing green card application for asylum, people who are granted asylum and they have applied for green card, that USCIS have stopped processing. I've never seen any memo to that effect. I've not seen any executive order to that effect. But this rumor, this was in the news. Now, the reason I'm bringing it up is that the American Immigration Lawyers Association, they have filed a request with the Department of Homeland Security. They filed a FOIA request asking the Department of Homeland Security to either confirm or deny whether they actually stop this processing. Because so far there has been no memo that talk about stopping it. There has been no executive order that talk about stopping it. It was only in the news. And as far as I'm concerned, I don't rely on the news. I only rely on official information from the official sources. So the American Immigration Lawyers Association have requested under FOIA. FOIA is Freedom of Information Request, asking the Department of Homeland Security to confirm whether truly they have stopped processing green card application for those who are granted asylum. So as soon as we get an official position on it, I will notify my listeners. So if anybody is asking me questions today about whether or not it is true that they have stopped asylum application, they have stopped green card processing for those who are granted asylum, I don't have the answer. I will still say no, that it has not been stopped. But again, the American Immigration Lawyers Association have submitted a FOIA request asking the Department of Homeland Security to confirm whether this is true or not. Once they confirm, I will come back onto the air and let my listeners know about it. Now, let's quickly go into question and answers because it's already 12:27 here and I have a lot to answer. So I think there is somebody whose question was not answered last week, and I understand that the person has called the office again this morning pleading that we treat the question today. So I'm going to answer the question first this morning. The question says, can someone be denied citizenship on health grounds? I have a friend that has been a permanent resident for 10 years. She's about to put in for her citizenship and just was diagnosed with HIV. Can this lead to a denial? This is a very straightforward case. The answer is no. Health grant cannot be the basis of a denial of citizenship. In fact, HIV cannot even be the basis of a denial of green card application. In the past, when HIV was fatal, it used to disqualify people from getting green card. But that was a long time ago. I remember I represented a client probably around 2005. That was about 20 years ago, who was HIV positive. And we were still able to get the green card approved at the time. I remember what we did at that time was to get the client to register with CDC, that is Center for Disease Control. For as long as you register with the CDC and you are getting treatment, they delayed the application for a long time. Probably they delayed for about 2-3 years, but eventually it was approved. But subsequently, after that, even the USCIS themselves, the Department of Homeland Security themselves, they took out HIV from the list of disqualifying ailment for the purpose of citizenship and for the purpose of green card. Now, green card requirement is different from citizenship requirement. For the purpose of citizenship, health ground is not a ground for denial. For green card, yes, health can still be a denial. Health can still be a ground for denial of green card. If somebody is positive for, I think, hepatitis A or something like that. But even at that, the person can still be approved if, one, they register with CDC, two, they show that they have their own insurance and they are not going to be a liability to the government. They provide their own insurance, they follow all the protocols. Of course, the case will be delayed, but it may still be approved. But the person can still apply for a waiver of the ground of inadmissibility. Health ground is still a ground for inadmissibility for the purpose of green card, but not for the purpose of citizenship. For citizenship, health is not one of the reasons. However, let me say this. Although health is not a reason, health and medical treatment may be connected. So I know that during citizenship, there are some questions whether somebody has been... No, I don't even think that question is part of citizenship. It's not. No, I take that back. That is part of green card application, whether somebody has obtained public charge and all that. Those are part of green card application. Health ground is not a ground for denial of citizenship application. Only criminal ground or evidence of lack of good moral character. Those are the things that are denial that can cause denial. Or maybe somebody seen as a terrorist or a danger to the United States. Those are the kind of things that they use. So health ground is not one of them. So let's go into the questions from last week. Is it the one that starts from my soccer?
You can just start from there. It's okay.
We can go in that order. I mean, she already posted them there.
Okay, thank you.
That way we don't go.
Welcome, sir. Okay, welcome too. My soccer is what I call you. I have two questions. So
First one.
So where are the questions?
Was it you passed it?
I don't think, no.
You passed it.
I saw 1 and 2.
Yeah.
Oh, okay, I'm sorry.
Okay. The first one, I have notice of action. In the notice I had given my job, they keep asking me the card. What I will expire.
That will expire.
They keep asking me the card that will expire on the 28th June 2025. I contacted USCIS. They said I can only contact it after 28th July. Is it safe to travel to Nigeria with advanced parole at this time? No criminal record or removal notice. I don't understand that first question. Can you go back to the first question?
They're wondering if
This is about 765.
yes,
So they want to know the EAD is expiring June 28th,
yeah,
and the employer is asking for
the
the
physical
renewal.
card, and it looks like they've
Maybe
already
has
given them the
extension.
notice, but the notice has the extension, so that's the federal law.
Well, in this situation, if you have a pending I-485 and you have a notice, the notice of action that says that your employment authorization is automatically extended for 540 days, that should be enough for any employer. So if your employer is insisting that you have to provide the physical card, let the employer know that their action may constitute a violation of federal law. If you have a lawyer, let your lawyer write a letter to your employer. That will be a violation of the federal law because it is federal law. It is the DHS that passed the regulations stating that when an application has been, when a renewal application for employment authorization was timely submitted and your case is still pending, your current employment authorization is extended for a period of 540 days for the purpose of employment. Now, to the second question, this automatic extension does not include travel. This is not about travel. So if you are going to travel, you need the proper advance parole in order to travel. You cannot use the extension to travel. The extension does not cover traveling. It only covers the employment so that you don't lose your job. But if you have provided the notice and your employer is not taking it, let them know that they are in violation of federal law. So if you have a lawyer, tell your lawyer to write a letter to the employer. Let them know that this will be a violation of federal law. In the alternative, you can also tell your lawyer to give you a formal letter in writing so that you send the letter to USCIS to request expedited processing. Let them know this is what your employer says. But I guarantee you the USCIS will respond by telling you that your employer is in violation of federal law. The next question. Can you please scroll up? I think this is. Oh, okay. Welcome, sir, and God bless you. No, I already read that. Good afternoon, sir. Yeah, there's no question on that. Okay, next question. Does someone with a B1, B2 visa need to do the new alien registration from this new administration? No, I already answered that question in my opening statement. If you enter with a B1, B2, you already registered. You are doing great, sir. Oh, thank you. Thank you. Next question. Does someone with a B1, B2 visa
It's the
visiting
same
from,
one. It's the
huh?
same one.
It's the same one, yeah. No, I see 30 days. Yeah, hold on. Does someone with a B1, B2 visa visiting from Nigeria need to do the new alien registration from this new administration and will stay more than 30 days? No, you don't need to. You already registered if you came in with a B1, B2 visa. The next question, what is the process of bringing your adopted child to the U.S. as a U.S. citizen? How long does the process take? Well, this is a little complicated. It's not that simple. Number one, I don't know from which country this person is talking about. When you are talking about adoption, it requires to determine which country you are adopting the child from. Because if the country is a member of the Hague Convention, then you have to follow the Hague Convention rule. If the country is not a member of the Hague Convention, then you have to follow the traditional rule. Now, the traditional rule, there are two ways to do it. If the child being adopted is an orphan, you will need to first file, I think, N600A to give you advance permission to advance an orphan. So if approved, that's when you now go to the country and identify a child that you want to adopt. The second way of doing it is to do the adoption properly from the country where you are adopting for, and then come back here and file I-130 petition for that child, the same way you will file for your child if you have a biological child. So it depends on the country you are adopting from. But most importantly, if you are adopting from a non-Hague Convention country, you need to follow the local laws of adoption in the country you are adopting from. Next question, please. Thank you for joining. Oh, this is probably from us.
Yeah, sorry.
Sir, this registration, does it affect those who have a working permit only? No, it doesn't affect you. For you to have a working permit, it means you already filed something. So if you have filed anything with immigration, you are already registered. This seems to be a continuation where the...
No.
Okay. The question, can I be denied for staying outside USA for 1 year during COVID? That is the only time I stayed outside USA since I got my permanent resident, but I was admitted in then when I was asked at the port of entry in 2021. So I don't understand the question. So is this person talking about citizenship or what? Because if you have already been admitted in, then what is the question? So if this person is talking about citizenship, yes, you will not be eligible for citizenship yet, because the moment you spend 6 months outside the US, 180 days, whatever number of days, weeks, months, or years you have accrued for the purpose of physical presence requirement of citizenship, those will be cancelled. They will be erased. So when you return to the US, you will start counting all over again. If your eligibility requirement for citizenship requires you to be a permanent resident for 5 years, from the time you return to the US, you have to start the 5 years all over again. If your category is 3 years, from the time you return to the US, you have to start the 3 years all over again. Because the moment you spend 180 days outside, the number of years you have accrued is erased and you start all over again. Next question, please. Good afternoon, sir. I request for change of name at citizenship interview from my present husband last name to my divorced husband last name, and it's 3 months I've not had for an oath ceremony. Well, when you request, okay, can I request to go back to my present husband last name because we are not divorced, or I should wait for their decision? Thanks, sir. Well, whenever you apply for citizenship and you say yes to the question whether you want to change your name, swearing in always take longer than usual. And the reason is very simple. Immigration officers, they are not judges. They are just regular officers. They cannot administer, they don't have the legal authority to do a legal name change. So for the legal name change to be granted, it has to be granted by the United States District Court judge. It is only a United States District Court judge that can grant a legal name change for citizenship purpose. So whenever there is a request for a change of name, they will start piling up list of names of people who request to change their name. So when they have enough names, that is when they will approach this district court, and the district court will give them an appointment. It is only after that they will schedule you for swearing in. So this is not a swearing in that can be conducted at immigration office or at any application support center. This is a swearing in that can only be conducted at the federal district court. So that is why it takes longer. So you have to be patient. It's already too late for you to start changing, because I'm sure your application has already been processed and probably be placed in line for your swearing in. So you just have to wait. The next question. How are you, sir? I have concern. We have completed I-130. I'm an American citizen and my husband is Gambian. We have been DQ since November. What does DQ mean?
Let me see. Oh, documentarily qualified.
Oh, this is talking about consular processing.
I think so.
Okay. Let me read the question again. How are you, sir? I have concern. We have completed I-130. I'm an American citizen and my husband is Gambian. We have been documentary qualified since November 2024 and we are still waiting for an interview 6 months.
I think that's it. I think just asking what's taking so long or why it would take that long.
Go back to let me see the name.
I didn't see another one from them.
Okay. Well, the process of getting an interview since COVID it has actually been taking longer than necessary. This is because many of the embassies were affected during COVID. You remember that many embassies were shut down during COVID. And another problem with embassies is that many of them, they have dual holidays. What that means is that they observe all the United States holidays. They also observe the foreign countries' public holidays. So all of them have a backlog since COVID. So it's taking longer time right now. But the only thing I can advise you, since you are a US citizen and this is your spouse, I will advise you to use congressional intervention. Go to your congressman and let your congressman help you contact the National Visa Center and the US Embassy to get an interview appointment. I intentionally mention National Visa Center because if the congressman contacted the embassy, I guarantee you the reply will be, we don't have your file. That's what the embassy is going to tell them, because they actually don't have the file. The file is retained at the National Visa Center until interview has been scheduled. So it is better for your congressman to contact both the U.S. Embassy and the National Visa Center in order to help you. This is something that I've advised a lot of people to do, and it works a lot. It's not 100% of the time, but at least it works more than 50% of the time. So you can give that a try. The next question, please. Now, have you...
I've already stopped.
Okay, yeah. Good day, sir. Please, what do you advise? My first immigration hearing stated for Thursday was cancelled today, Tuesday, and new date not given yet. Please, what can I do? Well, what you should do is to keep checking the EOIR portal. Go on Google and search EOIR case status. EOIR case status. So once the case has been removed, if you have a lawyer, your lawyer should call the court to confirm, because sometimes, for me personally, I don't rely on only the portal, especially if you are previously given a physical hearing notice. What if there is a system glitch? What if it was somebody's error? Maybe they just removed the thing by error. So if you are previously given a physical hearing notice, I will still contact the court. I will call the court to confirm, to verify whether the case has been rescheduled. But it is likely 9 out of 10, if the case shows on EOIR portal that it's been rescheduled, then it means it's been rescheduled. But the remaining 10%, that is the reason I will still call the court to verify. Then also, if you don't have a new date, if they confirm to you that it's been rescheduled, if you don't have a new date, check the portal regularly. Check the portal regularly. EOIR portal. It will ask for your alien number. Put in your alien number. It's a public record. It's not hidden. It will ask for your alien number. Just put in your alien number and it will tell you whatever is going on.
I just put the link for the portal in the description.
In response to this person?
Not in response, it's in the description of the video.
Okay. Yeah, I was just informed that the link to the portal has been posted on in the description to the video.
Description to the video.
Okay. So the next question. Good afternoon, doctor. Can 10-year green card holder travel outside the US? Oh yes, if you don't have any criminal issue, you can travel safely. But just make sure that you don't have any criminal issue. And of course, if you obtain your green card by marriage, if you are still married to that person, that you have to put your house in order. In other words, your spouse must know that you are traveling in case they call him or her to ask questions. Next question. Sir, I took to your advice and went ahead and filed tax with my ITIN, but I'm about to get married to a US citizen after filing. Can I still be affected? Well, once you get married to a US citizen, just go ahead and file your paperwork. Don't wait. So that even if immigration comes to you, you'll be able to show documentary evidence that you have a pending case. Next question. Good afternoon. Please, sir, I saw 2 TikTok info that Trump approved green card for junior colleges, senior colleges, and university graduates. Please put more light on this, sir. Well, I'm not aware of any green card that was approved for junior colleges, senior colleges, and university graduates. I mean, I can tell you there are lots and lots of fake information on TikTok, on social media. Some people just put in information there just to get traffic, so that a lot of people will be going to their click on their whatever TikTok. So I'm not aware of any such information. You can be sure that if there is any such information, we will be the first one to announce it on this podcast, because that is the purpose of the podcast, to provide information to people. Next question. Greetings, sir. Please, I have followed you live and would like to ask this question for help. I have a pending case for asylum, which I filed. No, I'm not.
Oh, sorry.
Okay.
Are you ready for now?
No, I have a pending case for asylum, which I filed by myself, attended first hearing. Is that the part 2?
No.
Look at the name of whoever sent it so that you can.
It's from us.
Okay,
Yeah,
so
it's this one.
so now I have an appointment at the court. Is it still possible I attend by myself? Thank you. Well, the decision to attend to attend a court hearing with or without a lawyer, unfortunately, that is not a decision that I can take for you. You will be the one that will take that decision. But I tell you that even with lawyers present, under this administration, cases are tough to deal with. How much more without a lawyer? And under this administration, they are looking for every excuse to deport people. They are looking for every excuse to deny application. I don't know if the writer of this question was here at the beginning when I was talking about the pre-termit notice. The EOIR already granted permission to immigration judges all over the United States to pre-termit application, asylum applications that were not complete. And without being a lawyer, I'm not sure if what you file is even a complete application. So you may be putting yourself at risk. I think it would be a smart thing for you to get a lawyer involved. But again, that decision, whether you want a lawyer or not, that is a decision you have to take yourself. Next question, please. The next question. Hello, doctor. I'm a religious worker and have gone through all the process. Presently petition for my I-485. My priority date is April 2022. I just want to know which date are they now. Can you please check the... Move to the next question while we wait for... Okay, we will let you know what the priority date they are processing now. I believe they have released the visa bulletin for May last week. So we should be able to give you that information. The next question. I want to divorce my current spouse and remarry my previous spouse. How will USCIS look at this since their record shows that I divorced her previously when I filed petition to bring her to the USA? Is it a continuation? The part 2, is that?
No, that's
okay. This is the whole question itself. Okay, thank you. Well, the issue here is that there is no law that says one cannot remarry an ex. In fact, I've had clients who were previously divorced, remarried, and then went back to the previous spouse. And of course, the green card was still approved, citizenship was still approved. There is no law that says you cannot remarry your ex. However, if you have been married before, you divorce, and you marry an American citizen, and you obtain green card, and then you go back to marry your ex, that will raise a red flag. Red flag does not mean denial. It simply means they will look more closely. It simply means they will investigate it more closely. So before you take that step, you have to ensure that your previous marriage to the American who filed for you have to make sure that there is no loophole. You don't give them any reason to doubt the legitimacy of that marriage. The law does not require that a marriage must work. The law only requires that a marriage must be entered into in good faith. You cannot enter into a marriage solely for the purpose of getting green card. That is what the law is against. But of course, if a marriage does not work, the law does not insist that every marriage must work. In fact, the officer who is probably going to review your application may have been a divorcee himself or herself. So that's not what the law is looking at. What they are looking at is this marriage, did you go into it in good faith? But if it fails, it fails. That's not a ground for denial. So you can remarry your ex, but just make sure your house is in order. Next question. Oh, do you have the priority date?
So, if you're in the U.S., it's unavailable. And then if you were doing consular processing, then it is February 1st, 2021.
Okay, and I think this person said April 2022. Okay, now, what I've been told is that for those who are outside the United States, the current processing time is February 1st, 2021. February 1st, 2021. For those who are in the United States, it is still unavailable. But generally, if those who are outside the United States is February 1st, 2021, then it means that those who are in the United States is still not current, because usually those who are outside, they are faster. They reach their priority date much faster than those who are inside. That is because they know that for those who are outside, it takes longer time to process, even after visa becomes current. So for them, they usually start much earlier. Most of the time, they start like 3, 4, 5, 6 months earlier than those in the US. So if they are still in February 2021, for those who are in the US, although it shows unavailable, you will still be looking at around October 2020. Next question, please. Okay. Can NVC call someone because a number called saying it was calling from NVC? In a long time, NVC has not been calling people, to my knowledge. In the past, they used to. They used to in the past. But lately, they have not been communicating with people over the phone. So you may want to treat the call with suspicion. You may want to treat the call with suspicion. What I will do, if you have a case pending with NVC, go and log in into your portal. Go and log in into your account. If NVC want to pass information, they will post it in your account. Don't answer any phone call. NVC, to the best of my knowledge, have not been calling people. This was in the past. I mean, when I say in the past, we are talking about 20, 15 years ago, not recently. That was before they even introduced the online filing system. So since they introduced the online filing system, they don't call people. If they have information for you, they post it. So just go and log in into your account and confirm whatever information they need. And if you didn't see any information, send them a message through the portal or send them an email that you received a call. Do they have any message for you? But I guarantee you 100%, if they need anything from you, they will post it on your portal. They don't call people nowadays. Next question, please. Thanks for all you do, sir. May God continue to bless you and your team, sir. Amen. Thank you. I'm a citizen. Went to Nigeria to get married, but unfortunately the marriage didn't work. Please, can I file the divorce from the US? Oh, yes. Oh, yes. Okay, it's a continuation. Okay, I went for my citizenship interview. I include her name as my new spouse. What can I do to remove her name as well, sir? Thanks and God bless you. Well, let me see. I thought he said I'm a citizen. So how can he be a citizen and still be going for interview? Or maybe at the time he went for interview, probably before he became a citizen. Okay, yeah. Just go, if you are already a U.S. citizen, so as far as citizenship is concerned, you don't need to do anything with USCIS. However, if your citizenship application is still pending, if you have not been sworn in, go ahead and file the divorce here in the US. You don't need to wait for the divorce to become final. Send a letter to USCIS to update them that you are already in divorce. You are in divorce proceeding with your spouse. But if your citizenship has already been approved, then you don't need to take any step as far as USCIS is concerned. The only thing you need to do, go ahead and file the citizenship. You can file the citizenship in this. I say citizenship. Go ahead and file for the divorce. You can file the divorce in the state where you live. And if you live in Texas, the requirement for you to file divorce is that you must have been living in the county where you want to file the divorce for at least 3 months, 90 days. So you can file the divorce here. You don't need to file it in Nigeria. The next question. I have a marriage-based green card. I want to travel to Nigeria in July and spend 1 month. Is there anything I should keep in mind? Any advice? Hope they will let me back in the USA. Oh yes, for as long as you don't have a criminal record. If you have a criminal record, my advice, don't travel. Don't go. It doesn't matter how minor the offense is. Don't travel. If you have an arrest record, criminal record, don't travel. However, if you don't have that, no, you don't. You have nothing to worry about. The only thing is make sure you are in good position with your spouse. Let your wife know that you are traveling, or your husband, as the case may be. Let them know that you are traveling. Just be on good terms with them. There is nothing to worry about. The next question. Good afternoon, sir. Thank you for all you do. I got married to a citizen and I'm about to file my paper. Is it okay she keeps her surname when filing instead of using my surname to file? Well, the decision to change a name is a decision between a husband and wife. USCIS has nothing to do with that. They don't insist that people should change their name. They also don't advise whether you should change your name or keep your name. It is not a requirement. That is a decision between you and your spouse. It has no bearing on the application. The next question. What of someone whose case is in the Board of Immigration Appeal? Can she go ahead and file tax now?
I think it was in response to the ITIN thing last week, where you were talking about to hold off and not file the taxes.
Well, but for somebody who has a case with the BIA, we will probably have a social security number. Because before your case gets to the BIA, it's either you have filed something with USCIS or you have been in removal proceedings. Somebody like that will probably have a social security number. The tax thing only affects people who didn't have social security number, those who are using ITIN to file. But if you have a case with the BIA, that has nothing to do with your tax filing. If you are working, go ahead and file your tax. So that has nothing to do. The issue of the BIA is that they are reducing the number of the judges, of the appeal judges, from 28 to 15. That's what they want to do. And of course, they also told BIA to expedite their cases. So that has nothing to do with whether you should file tax or not. If you are working and you have income, if your income is above the threshold, then you can file your taxes. It doesn't affect you. The next question. What document will you recommend for an F1 student to go around with in case he comes in contact with ICE? If you are on F1 and you are living in the United States, you should have an ID, either a state ID or a driver's license, because F1, they do get ID. If you don't have one, go ahead and apply for one. That is enough for you to go around with. Because I don't expect you to be going around with all your student paperwork, I-20, all those. No, you don't need to. All you need is just your ID. So if you don't already have an ID, go ahead and apply. You can only apply either for a state ID or a driver's license. And if you already have one, that is enough for you to go around with. Next question, please. Thanks so much, sir. If you were on R1 visa and it was cancelled, though the USCIS has not acted on it, please, what is the best way to stay on status back? Cancelled by who? I will need a follow-up on this, because as I always tell people, visa is not the same thing as I-94. So who did the cancelling if USCIS is not aware? So is this somebody who was granted who entered the US with a R1 visa, or did you at any time file anything with USCIS? Because if you didn't apply for anything with USCIS, USCIS is not going to act on anything. If, for example, you enter the US on R1 visa, not that you did a change of status. If you enter the US with R1 visa, USCIS has nothing to do with that. If the visa is cancelled, then it means that you are out of status. But if you apply for a change of status in the US and the R1 status was given to you, they will give you a new I-94 that will show the R1 status and will show the validity date of the I-94. So if you have that, that is issued by USCIS. If USCIS is going to revoke it, they will send you a letter, they will send you a notice of intent to revoke, and then they will revoke it. But if you have not applied for anything with USCIS, USCIS is not going to act on anything. If all you did was to apply for a visa at the embassy, R1 visa, and you are granted the R1 visa, and you enter the US with the R1 visa, even when you enter, they will give you a new I-94, and that I-94 will show the eligibility period, the validity date. Now, if the R1 visa was cancelled, is a little technical here. The moment you enter the US and the CBP officer give you a new I-94, that is what determines your status. So if your visa was cancelled and you have not filed anything with USCIS, USCIS may not be aware at that moment. But what I will do, rather than try to look for another thing, what I will do is to send a letter to USCIS to ask for why the visa was cancelled. And if they provide a reason, then respond to the reason. Because like I said, usually in the United States, if they are going to revoke whatever has been granted to you, they will first send you a notice of intent to revoke. But when you are relying on a visa that you obtain abroad, the Department of State, they are not used to giving people notice. They can just send you a notification or an email telling you that your visa has been revoked. So if I'm in that situation, if you don't have anything pending with USCIS, let your employer, remember R1, you are not the employer, you are not the petitioner, you are just the beneficiary. So let your employer be the one contacting USCIS and letting them know. But I also hope that you have your house in order, because if you are on R1, you are expected to work for the church, for the religious organization that petition for you. You are expected to work for the employer only. That is the language of R1, solely working for the petitioning organization. So if this revocation or cancellation was coming from the embassy and you have nothing pending with USCIS, let your employer contact USCIS and request to know why the cancellation is going on. So that is what will be my suggestion at this time. The next question. They mistakenly used my middle name as my last name on EAD, and I returned it to them for correction, but I never received the card back. Well, I don't know if you follow the right process, because there's a specific process for requesting correction. Is there a way you can post that process for someone? Or if you know whoever sent this question, maybe you can just respond to that person with the procedure. Okay, if you know the specific person who sent the question, okay, you will get a response on how to do the correction. I don't know. I'm not saying you didn't do it correctly, but I'm just saying if you did it correctly, normally they should acknowledge it and correct it, because we do that all the time. Whenever they make mistake, we correct it. But let me say this. If the error is not from them, they will not correct it. So that may be the issue here. If the mistake is not from USCIS, if it is from you, USCIS is not going to correct it. You will have to apply for a new one and pay for it. They will not correct it if the error is from you, except you apply for a new one and you pay for it. But if the error is from them, yes, follow that procedure. They will correct it and send you a notification. The next question. Please bear with me. Lately, in the last few months, I've been really stressed. Really stressed. That's why it seems I have cold. It is just stress. I've not been able to have enough time. Sometimes I sleep only 2-3 hours within 24 hours. So it's really been stressful. So just bear with me. The next question. Hello, sir. Thank you for all you do. Sir, I filed for my VAWA application I-485 and 765 inclusive in June 2020, and my VAWA was approved November 2022. I have my EAD and Social Security, my I-485 updated. Is that?
No, updated to fingerprints taken.
Okay, my I-485 updated to fingerprint taking on that same November 2022. But ever since, there hasn't been any update again. I went through my state senate office twice to reach out to USCIS, but was told my case is still in the time frame. I'm so confused. Well, every application has processing time. Every application has processing time, and so you have to look at the processing time. It is only when the case is outside processing time that is when they can expedite it. However, from the notice, I see that you said you went to state senator. Remember, state senators do not have the same access as federal senators. They are different. So everything we have been advising about using congressional intervention, we are talking about federal government, congressmen and women, and federal senators, not the state. The state senators may not have the same resources that the federal senators have. So we are talking about federal. Remember, immigration is not a state affair, it's a federal affair. The next question. Oh, was this part of last week's questions?
We're just not going. I mean, everything was posted, but.
Okay. Hello, sir. Can a deportee with regular ID travel by train or bus to other states after May 7th? What do they mean by deportee? Somebody who has been deported cannot be. Okay, maybe somebody who has been ordered removed and is yet to leave. Well, if that is the case, of course, if you travel, you always need to bear in mind that you have the risk. If you encounter ICE at any time, if you have a removal order against you, except you have a motion to reopen pending or something, you can be arrested at any time. So the risk is there. So even if you don't travel, the risk is still there. For as long as you have a removal order, that risk is always there. The next question. Hello, sir. Please, how would someone do a review of the pending case with the immigration court, as you said earlier, since the USCIS referred the case to the immigration court? What already submitted? Okay, with already submitted claims.
I don't think there's a follow-up question.
Okay. Now, as I've always said, USCIS and the court, they are not part of the same agency. USCIS is part of the Department of Homeland Security. Immigration court, they are part of the state, the Department of Justice. So they are not the same institution. So whenever you get a referral notice, that does not prevent you from submitting an application in court. It doesn't matter what you have submitted to DHS, to USCIS. If you are in removal proceedings, what you should do, especially with this pretermitted notice, what you should do is that if you are applying for asylum, submit a fresh application for asylum, complete a fresh application for asylum, make sure that all the questions are answered. Again, it depends on the reason why you are applying for asylum. If you are applying for asylum on the basis of membership in a particular social group, make sure that your lawyer submitted a brief, eligibility brief, because those are part of the requirement. Make sure your lawyer submitted eligibility brief showing that you are part of the protected particular social group. That will be one of the main reasons why a lot of cases will be pretermitted, because I've seen people submit asylum application without including the brief. Actually, I do it too, because it depends on a number of factors. But some judges will tell you, oh, you have to submit a brief, but some judges do not request it. So sometimes when judges don't request it, we don't do it. But now that we have notice that the immigration judges are going to be pretermitting cases, even for us in this office, we are going to have to go back to look at all our pending asylum applications and ensure that everything that is supposed to be presented, they are actually presented to the court. So what you should do, irrespective of the referral, submit a brand new application to the immigration court and submit a brief along with it if you are applying for membership in a particular social group, and then make sure that all the questions in the applications are answered. And if you have your supporting evidence, attach everything to it and submit it. But primarily, the brief is the major thing that I see as a challenge. So make sure you submit the brief along with it and make sure you answer all the questions. In the past, I've seen asylum applications that were completed and the question that says, have you ever been harmed in your own country? Applicants will just say yes. Then where it says provide explanation, they will not write anything. Meanwhile, they will not attach anything. Those kind of applications right now, they are going to be pretermitted. So all you just need to do, if this application was previously filed in court, make sure you file an updated application and complete all these things. If a brief was not previously included, make sure you attach a brief along with it. Make sure all the questions were answered so that you prevent your case from being pretermitted.
There's a follow-up. The person asked, can I think they mean pretermitted immigration court case be appealed?
Yeah, it can be appealed, but the problem is the notice. Appeal, you have 30 days to file an appeal. But remember, if you didn't go to court, you may not even know. If you look at the example that I gave before, we are still in April. Today is April 16. Let's say your case is scheduled for October 15. Then maybe by next week, a judge decides to look at your application and decide to pretermit the asylum case. Because you are not even in court, you already have at the back of your mind that your case is coming up in October. So you may not even follow up with the case to know that you have been ordered removed. And most of the time, when they pretermit a case, they will send you the notice by mail. Immigration court and even USCIS, they don't use expedited delivery method. They don't use registered mail. They don't even use certified mail. They use regular mail. They may mail this notice to your house. You may not get it. You may not receive it. They may mail it to an address where you have moved. Maybe you have not notified the court about your change of address. You are still planning that, okay, when I go to court in October, I will do that. So a lot of things could happen. So if for any reason you don't see it, and then by the time you realize it, the 30 days for appeal is over, that will put you in danger. Again, this is one of the reasons why I said anyone who is in removal proceedings, please check the EOIR case status regularly. Don't wait until your hearing date. Even if you already have a date in your mind, don't wait. Check the portal regularly. At least, based on the current administration's position, if I am in removal proceedings, I will be checking it weekly, at least once a week. Maybe you put it on your calendar or something that will remind you. Maybe every Sunday or every Monday or every Tuesday, every Friday, check the case status, EOIR status. It's not complicated. Just go on Google, type EOIR case status. It will bring up the website. Just click on it. It's a federal government website. I will ask you to accept that you comply with the rules. You click OK. Then it will ask you for your alien number. Just put in your alien number and click search. It will tell you what is going on with your case. If your case is still pending, it will tell you. If you have been ordered removed, it will tell you. If your case is administratively closed, it will tell you. If your case has been set for a particular date, it will tell you. So just check it regularly. So, because even if you have a right of appeal, is it not the same BIA that you appeal to that we are talking about now? It's the same BIA that they want to reduce the number of people working there from 28 to 15. It's the same BIA they are telling to expedite every case in front of them. So they just want to rush through all of these things. Donald Trump wants to do in 4 years what previous administration have not been able to do in 20 years. God will save us. The next question, please. Is it the one that said thank you, sir? Okay. Thank you, sir. I also saw on TikTok that President Trump approved 32 hours a week for employees and increased wages. Is this true?
No.
All these things are just complete nonsense, bogus news. President Trump does not even have the authority to do many of these things you are saying. He doesn't have the authority to do it. So those things are not true. Like I said, a lot of people exploit innocent people, especially on this immigration matter on social media. Many people post bogus things to attract people to their site. I mean, look at the time that somebody suddenly posted that American citizens who have dual citizenship are going to be denied entry into the US. All these things are not true. I still have a family member who traveled recently and just returned this week from Nigeria using American passport. She didn't get a visa. These things are all fake news. So don't let all these things confuse you. Please try to maybe check out facts yourself. Don't rely on everything you just see or hear on social media. Cross-check it. Seek second opinion as you are doing now. And I hope that a lot of people will not fall into unnecessary traps. So these things are not true. So far, immigration has not passed any law that affect immigration this year. Everything we are dealing with is what Donald Trump administration is doing by executive order or by policy changes. But as far as the law is concerned, the law remains the same. Next question, please. The abusive, can I see the beginning, because it seems to be.
No, you've already taken care of that. It's this one. But it's incomplete.
Can I petition for my 34-year-old daughter?
And then he sent this W, but it's incomplete.
Well, I'm assuming this person is a U.S. citizen. If you are a U.S. citizen, yes, you can file a petition for your 34-year-old daughter. The only problem is that they will not consider her as an immediate family member. So the petition will take time. But it's better to submit it and you join the queue from the date immigration receive it. The next question. How long does it take when you get approved from MVC for interview? Well, I think I've answered a similar question today. This is something that is not determinable right now. A lot of the US embassies all over the world, they have a lot of backlog, and they are trying to conduct the interview on a case-by-case basis, because they have so many cases that are due for interview. These same officers, they have to attend to those who are applying for visiting visa. They have to attend to those who are applying for student visa. They have to attend to those who are applying for immigrant petition, family-based, employment-based, temporary non-immigrant visas like H-1BR visa, student visa, those kind of visa that are time sensitive. So they give priority to those things, and then they still have to deal with other cases. So right now, since COVID, it has been extremely difficult to predict the timeline. So it's taking much longer than usual, but I'm not able to give you a specific timeline.
So one thing that I've noticed, or that we have noticed recently, is that you know how only non-immigrant visas applicants used to be scheduled for very early appointments. Now they're starting doing that for immigrant visas too. So as early as 6 a.m. scheduling people to go. So I know they're trying to maybe catch up.
Yeah, hopefully they will catch up very soon, hopefully. But right now, it is very difficult to predict the waiting time. In the past, we used to, but not anymore. The next question. Hi, my friend who's been undocumented for over 30 years and filed LIRF, Liberian Amnesty, but was denied and sent a letter with 33 days to leave the US. She wants to apply for the O1 or EB1 visa. So what's the question? Is there a part 2?
Yes.
Please scroll up. With the Biden updated D3 waiver, so she can go and get the visa approved in Mexico and return. In this current Trump administration climate, is it wise to apply or don't do anything till Trump leaves? Well, I don't even see how this person is going to be able to get EB1 or O visa, because there is something called 3-year bar, 10-year bar, and a permanent bar. So if this person has been here undocumented for over 30 years, is not going to be eligible for any employment-based green card. It is only for family-based that the person can apply for unlawful presence waiver and then go back to Mexico or to any neighboring country to apply for the immigrant visa. But that is not applicable to employment-based, because with the unlawful presence waiver, you need a U.S. citizen or a permanent resident qualifying relative who will show that he or she will suffer hardship if the waiver is denied. In this particular case, the employer cannot serve as a qualifying relative, and that is why the possibility of getting the waiver is very, very, is non-existent, except if this person has a U.S. citizen or a permanent resident immediate family member. And for this particular purpose, children are not considered immediate relative for this purpose. For this particular waiver, only parents and spouses can serve as a qualifying relative for the purpose of the unlawful presence waiver. Next question, please. Okay, as an O2 holder, how do I go about switching to an O1 visa? Of course, you have to file your own separate application from I-129. I-129 to apply for O visa. Is the same form for H-1B? And yeah, it's I-129. From I-129, that's what you need. So you apply for your own O visa. Of course, you get your own petitioner that will sponsor you, because O visa is not a self-sponsor. EB1 is self-sponsor, but O is not. Next question, please.
You already answered this one, I believe.
Oh, yeah, I already answered that. Yeah.
And that was the last one. For today. Yes.
This one.
No, that's her message saying that that's what we were stopping to.
Yeah.
Okay. Well, again, we will have to be stopping here today. We've been on this now for more than 1.5 hours, so we have to stop at this time due to time limit. We will continue again next week. So if you are just joining us for the first time, remember to invite your family, friends, and colleagues at work so that everybody will benefit from this wealth of information that we provide on weekly basis. We pray that this administration, the stress that everybody is going through right now will soon pass. God will help us, and God will continue to protect each and every one of us. Until next week, I hope to see you again. Remember to join us on other social media platforms where we provide information. I do know we provide information on TikTok, on what else? Instagram, Facebook, and of course, this podcast every Wednesday. So until next week, we hope to see you again. I remain yours faithfully, Dr. Olu Asekun.